guys, Ken Sudduth, and we're here with another edition of Legal Lions. And today we're at beautiful Bonita Springs, Florida at the FACDL conference. That is the Florida Association of Criminal Defense Lawyers. And I am with attorney Megan Blancho from the law office of Megan Blancho. And Megan will tell us a little bit about herself. She is not currently a criminal defense lawyer, but she'll explain why we're here and what she does. Megan, if you would just give us kind of a brief background about you and what you do and what you've done in the past. Catch us up to speed.
Absolutely. Attorney Megan Blancho, and I was licensed to practice here in 2004. I started off as a criminal prosecutor in Pensacola, Florida, and that I went to the Department of Health, where I was a prosecutor for the healthcare licensing board. So I prosecuted in the nursing section and podiatric medicine. After years of prosecuting, over 12 years ago, I started my own practice, and it is now dedicated solely to healthcare licensing defense throughout the state of Florida. That means nurses, massage therapists, chiropractors, any of the healthcare licensing boards. I handle the administrative licensing investigations by the Department of Health.
Great. That's interesting. So what I'd like to do is get a little Q&A, if you will, from the perspective of a health license person, be it a nurse or a doctor or whatever. So let's start with, I suppose you deal predominantly with nurses, is that correct?
Yes, they are the largest healthcare board in the state of Florida. So a lot of my clients are nurses throughout the state, in addition to them licensed massage therapists and the other smaller boards as well. Nurses have a lot of unique situations that they deal with in the hospitals or nursing homes, medication administration. So it can be accused if there's a documentation error, possibly drug diversion, or if they have a test positive on a drug screen, say for THC from a CBD product, or if they are arrested for a domestic violence charge or DUI. That is actually why I'm here at this conference, is to help criminal defense attorneys understand the unique position that their clients are in when they hold a healthcare license, that the arrest alone can trigger an employment exclusion under a level 2 background screening, and that they have a reporting requirement in writing within 30 days if they enter a plea other than not guilty to any criminal charge in any jurisdiction, to submit that in writing within 30 days to their board. A withhold of adjudication is a conviction, and there are certain charges that are enumerated violation of their Practice Act that is going to cause a problem or issue if they actually enter a plea to them. So want to make sure that nurses and other healthcare licensees are aware of the impact that a criminal charge and case is going to have prior to when the case finalizes.
Gotcha. So if any of these situations occur with a nurse, what would typically be the first thing that happens, or how are they notified? What happens next?
Well, sometimes they receive the notice from AHCA, the Agency for Healthcare Administration, that they have an employment exclusion. Sometimes they have an arrest that is an employment exclusion, but they fail to receive the notice. They may receive a notice of investigation from the Department of Health. There's times where the Department of Health is aware of a licensee being arrested, and they're waiting to see what happens with the disposition before they notify the individual that they have a pending investigation. It's important to contact the healthcare licensing defense attorney as soon as possible in the process. I work very closely with my clients' criminal defense attorneys throughout Florida to provide mitigation letters explaining the unique situation that the licensee is in with the criminal case and the best possible outcome. Sometimes it's a change of the charge for creative charging. Sometimes it's a dismissal through a diversion program. It's important to know that a withhold is a conviction for purposes of their healthcare license. If they receive a notice of investigation from the Department of Health, it's important to take action right away by hiring an attorney. The Department of Health has attorneys that are going to be assigned to the case to prosecute your license. It's important to have an attorney to defend the license.
So usually, if they have received a letter of investigation from the Florida Department of Health, what do you imagine they would do first, typically, in your experience? I'm sure this is maybe they have some knowledge that they're going to be receiving this, but sometimes it might be a surprise. I don't know. What is the scenario normally, and once they get this letter, how do they typically reach you?
So I have a lot of information online. If they look online for an attorney to represent them for their licensing defense with the Florida boards, I have information out there, blogs, videos, to try to help nurses know who to call when they have received this notice of investigation. If they're aware that they might be receiving a notice of investigation, often they've been terminated, that would also be the time to initially contact me so we can start putting things in place prior to even receiving the notice of investigation. One of the biggest mistakes that the licensee makes is that they receive a call from an investigator and they start answering questions and talking without realizing that everything they're saying can be used against them and is being turned over to an attorney to prosecute their license. So it's very important that they exercise their right not to make a statement and contact an attorney right away to assist them through the process. It's a confidential review process, so they don't know receive notice by checking their license status, because it's going to show clear and active online even when they're under investigation. And then the case goes from the investigator to be assigned to an attorney for prosecution. There's a way to request a copy of the department's investigative file. Every case at some point is going to be presented by the prosecutor to the probable cause panel at a confidential telephone meeting that my client and I cannot attend. And at that meeting, the prosecutor is going to make one of three recommendations. Close the case with no violation, meaning insufficient evidence of a violation of the Practice Act. A letter of guidance, which is non-public, non-disciplinary, but advises a licensee to take better precautions going forward in the future. Or an administrative complaint. And then 10 days after that finding of probable cause for an administrative complaint, that complaint is going to be online against the person's license. So it's very important to act in advance of that confidential meeting. What I do is I prepare a mitigation packet addressing the issues and concerns, oftentimes with my client's resume or professional reference letters, if they have any service awards, sometimes additional continuing education classes, and address the accusations. If it's an accusation that drug diversion is really a documentation error issue, if it's patient abandonment, was it really an employer issue? Maybe the person resigned effective immediately, but that doesn't necessarily mean that it's going to be patient abandonment. There's differences between employment abandonment and patient abandonment. So there's a lot of things to know and the nuances of how to address these complaints to try to get the case closed at that probable cause panel. If this case is closed, it will remain confidential. There's no disciplinary action, and the licensee's not responsible to pay the department's investigative cost. A lot of people don't know that if an administrative complaint is filed and the board enters a final disciplinary order sanctioning their license, that they're also responsible to pay the department's investigative costs. So you end up paying for your own prosecution. It's best not to wait to see how things proceed. You might think, well, I submitted an initial response and I haven't heard back for months. It's a very slow administrative review process depending on the type of allegation that's being investigated. The panel that I mentioned only meets about once a month, and they have to get cases on in advance of that. So it takes time to move through that administrative review process.
All right, so what else would you say? So once they've contacted you, and I know I would assume it depends, depending on whatever the situation is, but what typically happens next? So you would need to go to the review board, or what happens next? I know, a couple of examples maybe.
So I send a letter of representation, making sure that we have all of the initiating case documents. That's all we can get at that time, which means whatever the complainant submitted to the Department of Health, to make sure that we receive everything that we're entitled to for that initial review to submit an initial response to the allegations. My client will have no further direct contact with the Department of Health after they receive the notice of investigation. Everything's going to go through my office. I send my clients an email detailing everything that I need from them. I prepare the response and I have them review it before I finalize it and submit it to the Department of Health for consideration. If it's in the emergency action unit, then if it's downgraded, then it gets assigned to a different attorney. I always request a copy of the department's investigative file. and the Department of Health cannot recommend an administrative complaint against my client's license without first providing me with a copy of the file and an opportunity to respond. So it depends on where we're at in the stage of the process when the person contacts me. It's best if I can be notified as soon as possible in the process, even if before they even receive the notice of investigation, if they think that's coming. If, especially certain cases, I would have my client submit to drug testing. It takes a little bit of time to get hair or urine test results back, or complete some continuing education, or get reference letters and put together that mitigation packet. So the sooner in the process that you can engage legal counsel, the better off you are, and hopefully seeking and obtaining a case closure at that probable cause panel review. Now, for the panels that make a recommendation for disciplinary action, the mitigation packet also serves to help provide additional information to the panel to review, because if they make a recommendation for disciplinary action, they authorize the administrative complaint, then hopefully we're at the lower end of the guidelines for that disciplinary violation. I work to get positive settlement resolutions for my clients who do end up with an administrative complaint, and sometimes we need to go to hearing. We have an option of either an informal hearing before the board, where we do not contest the factual allegations in the administrative complaint, but we're providing additional mitigation for the board to consider, because it is the board in the end who decides how to handle the case as far as any disciplinary action. If we go to a formal hearing, that's before an administrative law judge, we are disputing the material allegations in the administrative complaint, and the judge makes a recommended order. In the end, we still go before the board. The judge only has the authority to make a recommendation of if there's a finding of a violation, and if so, if any, what type of disciplinary action should be entered. The judge can also make a recommendation to dismiss the administrative complaint. After that recommendation, then we still go before the board for them to review the judge's recommended order and to enter the final order. So that process, if we go to a formal hearing, takes a very long time to move through that process.
Is there anything else you would say that we would need to know about that nurses in that situation, or if not, then maybe talk more about doctors or massage therapists or any other area that you work with?
So the due process is the same for every healthcare license, as far as there's an initial it goes from the investigator to an attorney, and it's going to be presented to the probable cause panel for that board, that confidential meeting that my client and I cannot attend. There's definitely different issues that can address, or maybe a massage therapist, if there's and even nurses, about appropriate boundary issues and education and things that we can do. Whether there's a crime that relates to the practice, standard of care violations. There's certain cases where we need to bring in an expert to render a professional opinion. It is the expert in their particular field of licensure that deems whether or not they met the standard of care or failed to meet the standard of care, or if it's not an enumerated crime that relates to the practice, whether or not the criminal charge that they pled to does relate to the practice, and if so, why or why not. So it really is depending on the situation about what we need to do to prepare that initial response. And if we receive the copy of the file from the Department of Health, then we have additional time to review the file and submit an additional response for consideration. As I mentioned, the Department of Health is not required to provide me with a copy of that confidential investigation file unless they are considering recommending an administrative complaint. But that doesn't mean that every file that I receive that my client has an administrative complaint filed. A lot of times we're able to respond, provide additional information addressing what is stated in the investigative file to still obtain a closing letter.
Okay, well, is there anything else that you think is important for folks to know that we haven't touched on?
It's really just important to make sure that you're not trying to do this on your own, that you're not speaking with the department's investigator. Their role is very much similar to a police officer. They're there to gather information, to submit to a prosecutor. A lot of people make the mistake to think that it's the Department of Health calling, that they have to answer their questions, and that they don't have a choice. But you do have a choice in how you proceed, and it's very important to know with how you've worked for your healthcare license that you need to make sure that you take the effort and time to protect it and not try to handle it on your own.
Gotcha. And now, how can folks reach you? Your website, your phone number, what's the best way for them to contact you?
Any way through the website, meganblancholaw.com. Can call 850-375. It's 850-307-5665. And the phones are answered 24 hours a day, 7 days a week. I get back to you as soon as I can. Or the website will send you also to my email, which is meganblancholaw@gmail.com. That's meganblancholaw@gmail.com.
And we'll also put that up on the screen here at the end. All right, well, it's been a pleasure talking to you. Thank you very much. And this has been another episode of Legal Lions. Thank you.